No, and you take part of mine that I will get back. Goodbye. Goodbye. Madam Attorney General, if you could state your name, please.
Oh, sorry, Judge. Carrie Angie for the people.
Thank you.
And Assistant Defendant Nick Bukovich for Mr. Matthews.
All right. Your name, sir?
Nick Matthews.
All right. What are we doing?
Mr. Matthews indicated he'd like to speak to you, Your Honor. I did advise him against this. However, he would like to speak to you at this time.
Speak to me?
Yes, Your Honor.
For what purpose? What do you want to say?
I have evidence in my case. I wrote a letter also and submitted information into my case.
That, but what do you want me to do with that?
Well, this case is for year 2010 through 2013 for a total of $58,000 in child support. So for those 3 years, it's calculated up to $1,100 a month. At that time, I was on food stamps, and that amount would not have been an accurate child support amount. Now, as far as the warrant, I went to court in Tennessee in September 9th of 2021 on this matter, and a judge ruled on it. So I wasn't aware of a warrant or anything like that. I've sent certified mail.
Told all of this to your attorney because
I have.
But I can't do anything.
I have. My attorney refused to work for me as I needed him to.
Oh, so with your law degree, you were going to try to tell him what he needed to do. And it was some of that stuff he couldn't do. So he's not working for you.
Forgive me, Your Honor, for addressing the court, but it's not submitted any information that would get me home to my family. My employer has advanced me $10,000 towards my bond, get home to attend to my business on Monday.
I did send information that was provided to Ms. Gaines by Mr. Matthews' rights to A.G. Williams this morning. Obviously, A.G. Williams is not the attorney on today, but that was the attorney on the docket. So that's who I sent this information to and communicated with earlier this week about Mr. Matthews.
So you actually did your job, right, Mr. Bukovich? But nobody appreciates it.
This exchange reveals why defense counsel advised Matthews not to address the judge personally. Matthews believes the central issue is whether the original child support calculation was accurate, but this hearing is not automatically a forum for relitigating years-old support orders. Before the judge could revisit those figures, the defense would likely need a proper legal basis, supporting records, and a procedurally valid request. Simply saying he received food assistance does not, by itself, establish what income information the original court considered or whether the order was legally incorrect. Matthews also damages his position by accusing his attorney of refusing to work for him. Counsel immediately explains that he transmitted the information to the attorney assigned to the docket. Judge Simpson's sarcasm signals that he sees a client control problem, not attorney neglect. In court, information must be presented through the correct procedure, and counsel cannot promise an immediate release merely because a client has documents or employment obligations. Matthews may have sincere concerns, but is speaking over the person best positioned to organize them legally. Do you think addressing the judge directly helped him, or did it weaken his credibility before the bond decision?
I got you. Anything else you want to tell me?
Yes, sir. I was extradited from Texas. From here, it's been a total of 27 days that I've been incarcerated. The letter that I wrote to you explains a lot more in detail. I have $10,000 for my bond so that I can be released to get back to work. My wife
requires 25%. So if you're at 58, I'm going to be somewhere around 16, 17,000.
14,500.
I have your bond in this case set at 16,80462.
Yeah, the numbers that were submitted for the total is about 3 different numbers. And I'm not sure which one is correct. I received a letter in the mail.
Well, if you paid the 16,000, it's going to go to where support should be anyway. So I'm not changing the bond.
Right.
Anything else?
No, sir.
What do you want me to do with this case?
Yep.
I just opened that to the floor, I guess. So I don't know.
You asking me? You're asking me? Like,
Huh? Whoever wants to answer me.
well, I believe that the 10,000 should be accepted.
Okay,
Home to my wife and sons.
10,000. Then you need to come up with about 6,000 plus more.
This case is between the years of 2010 and 2013.
Okay, and somehow those children had to survive without you paying your child support.
It was only 3 years. My son is 30 years old now.
Okay, and it's owed.
And I want to pay it, sir. I do want to pay it. Can I start with the $10,000?
We will take the 10. Then you got to come up with 6. I told you that. I mean, I'll keep repeating myself as long as you want to keep repeating yourself. I don't have a problem. I got all day.
I mean, you just send this form.
When is the court date?
He'll give it to you. Yeah, I can guess.
I've spoken to him one. Whether he's still just
We wait a little longer. He'll probably have 12,000.
What?
Yeah, the longer we go. Just a lot more money. I'm thinking.
This is the offer we talked about on Tuesday when Jay were waiving up. If you pay the certain portions down, they will reduce the charge.
To do that.
Wow.
You'll be waiving, Your Honor.
Pardon?
You're waiving, Your Honor.
Okay. Thank you. That is almost lunch. So you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
When would the hearing be?
Pardon?
When would the hearing be?
Soon. I will set a date.
Okay.
I mean, this isn't a negotiation. You want to waive or not?
Well, I
You
do.
want to waive or not?
I do, but I don't understand all the court proceedings because
Okay, and that's why
I'm not a criminal.
to listen to you.
He's been doing this for 2 years. And I'm not a criminal.
2 years long. Do you wish to waive your preliminary examination?
Yes.
You will also waive?
Yes, Judge. Thank you.
I thought everybody was. All right. Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Bukovich, with your 2 years experience, can you do this part?
This is the hearing's most legally significant turning point. By waiving the preliminary examination, Matthews is not pleading guilty. He is giving up the hearing at which the prosecution would have been required to establish probable cause that an offense occurred and that he committed it. The case now moves to circuit court, where his attorney can continue negotiations, review the evidence, file appropriate motions, or prepare for trial. The judge repeatedly asks whether Matthews truly wants to waive because his questions reveal uncertainty about the process. A waiver must be knowing and voluntary. The court cannot safely accept it while the defendant appears confused about what he is surrendering. Matthews' statement that he is not a criminal does not answer the procedural question and risks distracting from the advice counsel is trying to give him. Notice the strategy used afterward. Defense counsel stands mute, so the court enters a not guilty plea. That preserves Matthews' position without requiring him to make another potentially damaging statement. Would you have waived the hearing here, or required the prosecution to present its probable cause evidence first?
Go ahead.
To waive formal reading information and stand mute as to the charges.
Defendant having waived formal reading, stating mute, court will enter a not guilty plea. Pre-trial in this matter will be set.
1:30, Judge Sled.
Here's your date. April 9th, 2026, 1:30 before Judge Sled.
Well, I have one question, Your Honor. If I pay the bond to get out, I reside in Tennessee. This is where my home is. Will I be allowed to go home and then come back to court?
If you pay the bond, you're going to have to stay in Michigan until the court gives you permission. So now, this having been waived, Judge Slay would be the one that you'd have to ask.
Well, where would I stay here in Michigan?
Where would you stay? Well, we're providing accommodations at this point.
Well, once I get out.
I don't make hotel reservations. I don't push. I can stay at Childers' house. This thing.
Listen, this is my life.
I understand that, sir, but you're asking me questions I can't.
27 days incarcerated for no reason.
No, there is a reason. You pay your child support. Now, if you want to keep going, I can do something else with the bond. But I think we're done here. Thank you.
This is my life, man.
Yes, I know. And you've taken part of mine that I will get back. Goodbye. Goodbye.
Judge Simpson, if I could just say, and I think he may be too proud to say, Joy Gaines, Senior Assistant Public Defender, his wife contacted me, and either today or yesterday, their son was murdered within the past year, and this is the court period time. So I think he is under a level of stress.
I understand.
But I just want to apologize.
It's a motion, a way to do that.
Yes.
Just to listen to Mr. Vukovich.
Yes.
Mr. Vukovich could have gotten that before the court. It could have been addressed. He wanted to handle it his own way. So my condolences to his family, but this isn't the way it's done.
Yeah.
Thank you.
The hearing ends with Matthews bound over to circuit court, a not guilty plea entered on his behalf, and no reduction in the existing bond. Judge Simpson's decision is driven less by Matthews' immediate hardship than by the unresolved financial obligation, the amount required under the bond arrangement, and the court's concern that Matthews continues trying to negotiate directly after receiving clear answers. His offer of $10,000 demonstrates access to substantial assistance, but it does not compel the judge to accept less than the amount already required. The exchange about returning to Tennessee also matters. Posting bond does not automatically give a defendant permission to leave Michigan. Travel restrictions are conditions of release, and because the case has now been transferred, Matthews must ask the circuit judge for authorization. His question about where he would stay may be practical, but the court is not responsible for arranging housing after release. The final disclosure about his son's murder provides important emotional context and may explain his distress, but it does not erase procedural requirements or justify disregarding counsel. Judge Simpson acknowledges the tragedy while emphasizing that the information should have been presented through the attorney. The broader lesson is that personal advocacy can become self-defeating when frustration replaces legal strategy. Did the judge strike the right balance between compassion and enforcing the court's rules? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.